Welcome to our seminar series. I am very excited to present our topic today. My name is Martha Shapiro, and I'm the Director of Programs at Senior Concerns. If you're not familiar with our programs, that includes our Meals on Wheels program, which delivers to Thousand Oaks, Newbury Park, Westlake, Oak Park, and Agora. We also run an adult daycare program in Thousand Oaks. We have a caregiver resource center. We have senior advocacy services, and we also have legal and financial concerns program. And our seminar today is part of our legal education series, and it's called The Legal Reasons to Have Advanced Care Planning Conversations with Your Loved Ones. It's a long title and it's a packed topic with a lot of really wonderful information for you today. We have two speakers with us, so I'm very happy to introduce Ken Kossoff, who's been an attorney since 1983 and in practice in Westlake Village since 1998. Ken is an estate planning, probate, and trust law specialist certified by the State Bar of California Board of Legal Specialization. And I'm also introducing Katie Wiltfong, who is a medical social worker with a Master's of Social Work from the University of Southern California. Katie has a background in hospice care and has worked the last several years for Buena Vista Hospice, Home Health, and Palliative Care. Through her experience working with older adults and those facing terminal illness, Katie co-founded Solo Aging Solutions, a company dedicated to providing informed healthcare decision-making to clients when they are no longer able to do so for themselves. So we're so thankful to have you both share some of your expertise with us today. And I will turn it over to Ken to start us off, but I'll just say if you type your questions in as they come to you, at the end of the presentation, we'll do our best to get to all of your questions. So thank you both for joining us.
Thank you.
Good afternoon, everybody. Thank you for coming. I am going to be talking more about the legal discussion, whereas Katie's going to talk about some of the more practical issues. I want to emphasize the legal issues to the extent that you understand that if people are going to be looking, essentially healthcare providers, people in an emergency room, in an ICU, in hospital administration and legal are going to be looking at a healthcare directive, there are aspects, very significant legal aspects that they are going to look at with healthcare directives and healthcare decision making. But I do want to emphasize the importance of the discussion that Katie is going to have, that everybody needs to have with their agents under their healthcare directive or the people they're considering appointing as agents under their healthcare directive, because this is a much bigger issue than just whether the document complies with California law. That's barely the beginning of the inquiry. So with that, what I'm going to be talking about a lot is various provisions of the California Probate Code. They're under the title called the Healthcare Decisions Law. And it starts with some of the basic definitions, such as it will use individual healthcare instruction, which is a person's written or oral direction about a healthcare decision for a patient. And a healthcare is exactly what you would think it would be. Any treatment, service, or procedure to maintain, diagnose, or otherwise affect a patient's physical or mental health decision. Although there's a reference to mental health decisions, it does not include placement in a mental health facility, convulsive treatment, or psychosurgery. So it is not unlimited when it comes to mental health. There are other protections out there under various provisions of the law. And a healthcare decision under the probate code is what you would expect to engage or terminate healthcare institutions, healthcare providers, approve or disapprove of tests, procedures, and also to make the ultimate decision to provide, withhold, or withdraw artificial nutrition and hydration and all other forms of healthcare, because as we will see later on, the probate code recognizes that the prolongation of life through medical technology is not necessarily always to the benefit of the patient, and quite honestly, a lot of times is counter to what the patient would want had they put their desires in a healthcare directive, which is exactly why everybody over the age of 18 should have an advanced healthcare directive. So what is an advanced healthcare directive? It's generally it is a written document. It is sometimes called a durable power of attorney for healthcare. In other states, it is called a living will. California has combined the names advanced healthcare directive or directive to physician with a durable power of attorney for healthcare. But essentially, what the person is doing and the person who is signing the document is called the principal, is they are appointing an agent to make their healthcare decisions for them. They might be called something different than an agent, an attorney in fact. That's the durable power of attorney part of it. The name is less important than understanding that they are going to be making very significant decisions for the principal, and hopefully with the detailed guidance of the principal. Now, who may sign a healthcare directive? Any adult with capacity over the age of 18, that means an adult. And I can't emphasize the importance of every college student before they go off to college signing an advanced healthcare directive to allow their parents to make decisions and communicate with the university healthcare system, because without a healthcare directive, the university likely will not tell the parents anything, because they treat the student, if they're over the age of 18, as an adult. And I also think for some students who are under the age of 18, they treat them that way anyways. So it is very important. The other thing I like to mention is that the first case that went to the US Supreme Court on this issue was a young woman named Nancy Cruzan, who I believe was 22 when she had the car accident that put her into a persistent vegetative state. The other one that had got a lot of publicity during the George W. Bush administration was Terry Schiavo in Florida, and I think she was 29, whatever event happened that prevented her from making her own healthcare decisions, and ultimately resulted in a battle between her parents and her husband. The capacity, what is the capacity to make a healthcare decision? It's to understand the nature and consequences of your decision, and the benefits versus the risks, as well as the alternatives to the proposed healthcare. There will be times in people's lives when healthcare providers will propose some alternatives, and some of those will be totally unacceptable to the patient. But if the patient can't speak for themselves, somebody else has to make that decision. And California law pretty much presumes that everybody has legal capacity, whether it's to create a healthcare directive or to enter into contracts or any other types of decision making. Katie, do you want to pick up here?
Yes. So when selecting a healthcare agent, there's a lot of factors that should come into play with making the decision of who would be the best person to speak on your behalf in the event you were temporarily incapacitated or maybe permanently capacitated. And that kind of begins with looking at the person's maybe age and health status. A lot of people think they automatically need to select a spouse, but it's important to really take in factor if that person has their own underlying healthcare concerns or may be older or not likely to be there to survive you. It's a big factor in kind of making sure that just because someone is legally married to you, they might not be the best fit to serve in that role. Another big indicator is where they live. We've been able to do so much with FaceTime and Zoom, but it really doesn't take away the ability to be there, feet on the ground, put eyes on someone. I know from working in home health and hospice, a lot of the time there's very well-meaning relative who wants to be very involved, but can't fully understand the gravity of the situation about someone's current health status, because they're seeing photos, they're hearing, oh, your brother had a good day today. Well, that might not necessarily mean he's improving. It just might mean he didn't have a seizure. There hasn't been any new infections ruled out. So having someone who's able to be there to speak to physicians and really help navigate your care is important. Your healthcare agent should also be able to separate their own beliefs from what you ask them to do. So when having conversations with a healthcare agent about your medical wishes, it's so important to make sure that they can follow what you are asking them to do. They can truly step into your own shoes and not have any cultural or religious beliefs that might make your decisions that they need to make affect their own. That kind of ties in also to making sure your healthcare agent can separate out their own emotions. I have a very good friend who is very close with her parents, and she has made it very clear that if they ever are to have any type of event where they're needing life support, she would not be able to remove them or elect palliative or natural death. And her parents don't want that. They have voiced that they would not want any aggressive type measures at a certain point. So someone who has that inability to really step out and follow her own parents' wishes shouldn't be put in the role of being a healthcare agent. A healthcare agent should also be really comfortable working, or not working, but being in a hospital in a medical setting. A lot of people have the white coat syndrome, and it can be very overwhelming, very uncomfortable to step into a hospital setting. So if you're asking that person to be your healthcare agent, it might be putting them in a place that they're just not going to be comfortable, maybe advocating or speaking up, because it's so important to be able to have conversations with physicians, ask questions, sometimes challenge decisions that are being made. And lastly, I've always preached to people, it's so important for someone to know the awareness of your baseline. And by baseline, I mean knowing what your current healthcare, emotional, physical, mental status is. A lot of the times as we age, when we go to the ER, there are certain medications that can cause confusion. A urinary tract infection can bring on a sudden onset of delirium. Medications can cause dizziness. And older adults are always thought, unfortunately, to probably have some form of dementia. So if your healthcare agent is aware of your current status and how you act in your day-to-day life, they would be able to step in and say, this behavior is new. This change in her mental status is brand new. And you might receive the care you need a little bit quicker than if the emergency room, very well-meaning doctors and nurses are just responding based on what you're presenting with and what your age is. A healthcare agent really is going to be your biggest cheerleader and take on that role of truly, again, being able to step into your shoes and make decisions for you as you would do for yourself.
And I do want to just emphasize a couple points that Katie made. In my practice, I have seen on a number of occasions, it doesn't happen all the time, but it happens pretty regularly, where one spouse will not appoint the other spouse because the other spouse will not honor the wishes of the spouse who's making the appointment. And it is also very difficult for parents to appoint children. I mean, maybe when the children are 40 or 50 and the parents are further up there, they might be more appropriate for it, but it's a very difficult situation for everybody involved. So it takes a lot of care and a lot of thought and discussion with the person, as Katie will talk further about. But I'm going to get now to the legal requirements of the Advanced Healthcare Directive. First, and by the way, I'm going to be talking about some forms of healthcare directives, some of which are really intended to be completed by people without the assistance of an attorney. So I'm not saying that legally an attorney is necessary, but there are some perils of the failure to complete the healthcare directive quickly. And the first requirement is that the directive contains the date of its execution, the date you sign it. There are healthcare directives out there that don't have that date. Now, are the emergency room personnel going to focus on that? Maybe not, but if it gets to legal, then they may well take a look at that. Secondly, the advanced directive has to be signed. There's a lot of people who like to think about healthcare directives and never quite get to the point of signing it. And so, date it, sign it, needs to be clear who you are, who your agent is. And then the advanced directive is either acknowledged before a notary or signed by at least two witnesses who satisfy the requirements on the next couple of slides. And I'm not going to spend any real detail because these requirements for witnesses rather than notary can be overcome and can be complied with. But if you look at each of the lines, you need to comply with what's on this slide, you need to comply with what's on this slide, and you need to comply with what's on this slide. And if you get it notarized, you don't have to comply with any of those, with the one exception that if somebody is in a skilled nursing facility, or really any facility, they need to have somebody else sign, an ombudsman or somebody there who is capable of acting as an independent witness, even if a notary is there. So my point is that it is important to comply with the requirements. And even with the notary, makes it easier for everybody other than somebody who's a resident of a skilled nursing facility, again, where we need the ombudsman or patient advocate. Okay. I think now in terms of the forms that are available, there's no magic about any particular form. But in my experience and my understanding, more importantly, my understanding from people I know who have worked in emergency rooms and intensive care units, and from some of the literature out there, there's three primary forms that are recognized in the state of California. The statutory form, which is a form created under the probate code that you could find online, statutory form of healthcare directive, and you could complete it. And if it's completed properly, it is enforceable. The California Medical Association form, they put out a form that's not available online. They charge on a per form basis. And then the California Hospital Association form, which also is available online in multiple languages and is very well recognized. And I could spend the rest of the hour, and other attorneys could spend even longer, and attorneys do have disagreements over this issue, but my belief is that the best thing you could do is use one of these forms that the healthcare providers are familiar with, because if there is an attorney drafted form, the first thing that is going to happen to that form is that it's going to be sent to legal. And if it's a Friday night at 2 a.m, or even if it's a Wednesday at 10 a.m, it's uncertain when legal is going to be able to review it and get back to the healthcare provider. So I think it's important to provide a healthcare directive that people who work in the fields are familiar with, and that is one of these three forms in the state of California. Kaiser also has its own form. So Kaiser is something that if you're a patient or a member of Kaiser, that use the Kaiser form. They're familiar with that. There's also probably the best known form among those put out by various organizations is 5 Wishes. And 5 Wishes has been around for 25 years. The organization claims that with the exception of 4 states, and California is not one of those states, with the exception of 4 states, they claim their document is valid as a healthcare directive. For a long time, I think a lot of people's view in California, the views of a lot of attorneys, was that 5 Wishes helps direct the health care agent, but it's not legally effective. And I think there's, I haven't confirmed the claim by 5 Wishes that is valid in California, but that is a form that's available. Even if you're not using it as your form, it does go over some of the issues that could help your healthcare decision maker make their decisions. Katie, do you want to talking about those decisions?
Yes, absolutely. So some of the concerns I see being a social worker and someone who assists people with filling out advanced healthcare directives, or works with people who are now discussing those wishes and those conversations that were had many, many years ago. A lot of the times I find people meet with their attorneys, they do their trust documents. Part of that is the advanced healthcare directive. And then they keep it in that big binder that's given to them by their attorney, and they stick it in their closet, and it's never talked about again. So if that person has not brought that binder down in 20 years, it's usually most certain that they have never shared with their power of attorney who they've elected that even they are power of attorney for them, and certainly haven't discussed what those wishes are and what that person should be following. So in having the discussions with a power of attorney, it's so important to first make sure they're comfortable. Is that a role that they want to step into? I always say it's a really good indicator if you start to talk to someone about your views, your values. Start to talk about those scenarios and those what ifs. What if I am to drop to the ground right now? I do want CPR, and and kind of that discussion about how much you would want done for you. If the person you're trying to have this conversation with responds with no, 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 I don't want to hear it. Let's not talk like that. That's nothing we should approach. That person might not be the right fit for you, because someone who is going to truly step into the role as a healthcare agent should really be interested in knowing what your views and your wishes are, because in the event they have to step into that role, they'll want to know how they should respond in certain scenarios. I definitely am a big proponent of using different questions and kind of imaginary occurrences to really lead that discussion, because it can be very heavy talking to someone about your own views on your mortality. I think it's always important to talk about what is your quality of life, because I think that really changes how far you take certain scenarios. You might want CPR and to be put on a ventilator as long as you haven't had irreversible brain damage. You might want dialysis. You might want all these curative measures. But then the same person could say, but if I can no longer speak for myself, if I have any type of cognitive impairment, some people might say, if I have physical impairments, I no longer want to receive this level of intervention. And so talking about those type of scenarios and when really those kind of cutoffs are, when someone says, I no longer have quality of life, I wouldn't want you to pursue anything further. These are really heavy conversations, but really important for not only the person creating the advanced healthcare directive to have, but also for the people that they are electing to fill their shoes. So one of the biggest takeaways I would say from today is really just that importance of, when you get to this step, when you create your advanced healthcare directive and select the people that you want to list, make sure, first of all, they know that they're listed, that they know your wishes, and that you're continuing this conversation, because our views and our values are always evolving and always changing, especially when there's a change in our health status, when we age. There's just so many different scenarios that can come into play when looking at what we want for ourselves. And so one of the biggest takeaways again today, I hope everyone continues to have these discussions past this seminar.
Yeah, it's both past the seminar and past your lawyer's office, because your lawyer is not likely, number one, going to understand exactly really what happens in an emergency room or in an ICU, is not really going to be familiar that, maybe watches the same medical TV shows where CPR works a lot better than it does in real life. And it really is important to talk to people in the healthcare field who know the practicality of these issues. And to emphasize what Katie also closed by saying, your views are going to be different likely on healthcare directives if you do it first at 65 than they will be at 75, than they will be at 85. Not for everybody, but for lots of people.
And so another thing I wanted to also talk a little bit about today is, what is a POLST form? And that's a physician's orders for life-sustaining treatment form. This is something that you usually are given in either a doctor's office, at a hospital, in more medical type settings. It's not something an attorney would complete with you, but there is often a lot of confusion about the difference between an advanced healthcare directive and what we call a POLST. So this form, and we will provide the slides to you so it'll be a little easier to see, but it just goes through different types of interventions that someone can elect, whether they would want cardiopulmonary resuscitation or CPR. And if that is the case, then they would follow that with having full treatment, everything to kind of prolong life. If someone does not want CPR, they would typically select either selective treatment or comfort-focused treatment. And those would depend on what their health status is and what their goals of care are. And the next section would talk about a feeding tube, whether or not someone would want to receive any artificial hydration or nutrition in the event they could not swallow. This form is typically filled out by the person who's making the decisions, or it can actually be filled out by the legally recognized decision maker or sometimes next of kin, which is very different than the Advanced Healthcare Directive. This form is signed by a physician, not a notary, and usually signed at the bottom by the person who is actually making the decisions. So on the next slide, I kind of lay that out a little bit further. But this form is equally important for people who are reaching a point in their lives where they need more medical support. Maybe they have a terminal illness or they're aging. It's not a form recommended for everybody over 18, like an Advanced Healthcare Directive is. It typically is supposed to transport with each person, just like Advanced Healthcare Directives. I always recommend have several, have copies. When you give one to the hospital, they will assure you that they will put that into your record. And I will assure you that if you go back a month later, it will not be in your record. So always having several copies of either of these forms is very important. This form really is what makes someone a do not resuscitate. So there's sometimes confusion about an Advanced Healthcare Directive having that language. And this is the actual physician's order that allows them to legally not give you CPR or treat you further than you want to be treated. It's not meant to replace the Advanced Healthcare Directive, but more or less it complements the Advanced Healthcare Directive. And on the next slide, there's a little bit of a comparison because again, it's so confusing for so many people, the differences. The Advanced Healthcare Directive, again, being for anyone over 18, doesn't matter your healthcare status, it's just so important to have in place. Whereas a PULSE is really for anybody who's older or is having any type of serious illness. Some hospitals are also now giving it to people who are a little bit younger, just because they're maybe having a surgery and they want to make sure that they know what that person's medical wishes are in the event there's any complications in surgery. The Advanced Healthcare Directive gives general instructions. It's not very cumbersome in talking about really what your healthcare wishes are, whereas the PULSE gives a little bit more clarification on what your medical interventions are, if you would want them or not. But again, it is not encompassing everything that can happen. So that's why these conversations outside of these forms are so needed. And while an Advanced Healthcare Directive appoints a decision maker, and the only person who can sign an Advanced Healthcare Directive is the principal or the person who's actually creating that form, the PULSE form can actually be signed by your decision maker. But those are kind of the main differences between those forms, which I know can get a little confusing.
And I was one time talking to a sheriff's deputy, and I want to emphasize that it all depends on how the people are trained, whether it's the EMT, the paramedics, or the deputies. And this was a number of years ago. But what he was saying is that his training was that if, when they're accompanying the paramedics, there's a PULSE, and the PULSE is do not resuscitate, no code, they will allow the person to die at home. If the person wanted to die at home, it doesn't mean that somebody doesn't call 911 because they get scared, or a well-meaning neighbor knows that something's going on, so they call 911. Whereas if there's an Advanced Healthcare Directive without a PULSE, and the agent is there saying, don't take them to the emergency room, they're going to take them to the emergency room. Again, I want to emphasize that this is dependent on training, but this is how at least one sheriff's deputy was trained. So it is a very good supplement if your doctor thinks it's appropriate that you have it. It is absolutely something you need to discuss with your primary care physician or any specialist you might be dealing with. So now I'm going to talk about a few more of the legal issues. Is one, does a healthcare directive become effective? If somebody initials a paragraph or signs on the appropriate page where it says it becomes effective immediately, and there are circumstances where people might want that, otherwise it becomes effective when the primary physician determined that the patient lacks capacity to make their own decision. So we all think in terms of primary decision makers as our primary care physician, if we have one these days. A lot of people don't really have a quarterback because insurance will only do so much. But we think of a primary care physician as the physician who knows us best. If that person is not available, or maybe doesn't have admitting privileges to whatever emergency room you're taken to. It may be a hospitalist who doesn't know you. Even if they treated you, 4 months earlier, they're not likely to remember much of anything because of the volume of patients. So somebody's going to make that decision as to whether you have capacity to make your own decision. In the absence of any limitations set forth in the healthcare directive, an agent is pretty much empowered by law to make whatever decisions that the principal could make just on the principal's behalf. That includes organ donations, authorization of autopsies, and dispositions of remains. If you don't want to be an organ donor, it's actually now important to explicitly say that in your healthcare directive. California essentially made organ donation a default. As I think everybody knows, there's a lot of people who die waiting for organs, and it's been hard to try and convince people to become an organ donor. But as I also tell clients, if you really want to be an organ donor, make sure it's on your driver's license, because that is likely going to be the document that they see before your healthcare directive. There actually are some companies out there, and on the California Medical Association, not on the form, but in the booklet in which the form is sent by the California Medical Association, there's a little card you could put behind your driver's license. And on that card, with the CMA form, it basically gives the name and number of your agent if you write that in legibly. And then for some of the private sector companies, create databases where the forms can be obtained by the healthcare provider, whether you're at home in the Conejo Valley or somewhere around here, or whether you're in England visiting and just having a good time when you end up in an emergency room. So it's available by the internet or by fax. So what does a healthcare agent need to do? First and foremost, if you are a healthcare agent, what you want to do is make sure you have the understanding of what your principal would want you to do in those circumstances. Even if you're thoroughly familiar with their medical care wishes, their end of life thinking, it still is a very difficult position for most people to be in. And so the important point is that you don't want to act as if or think you're making a life and death decision. I think what you want to think is you're their spokesperson. You're merely transmitting to the healthcare providers what they would say to the healthcare providers if they were capable of speaking for themselves. But the most important point is that you need to make your decisions in accord with what the principal wants, given these circumstances, not your personal values. So again, there are some people who, for religious or other reasons, would never authorize the cessation of life support, or say don't give them life support. But you're not supposed to think about your own personal values. You're just supposed to think about the values and desires of the principal. And if you don't really know that under these particular circumstances, because we can't always cover 100% of the circumstances in which we might be called upon to make these decisions, you think about the principal's best interests. Would they want to remain alive given their prognosis? And sometimes, as Katie was saying, you really need to be able to advocate and to ask questions. What do you mean by this? It's like, how long will they have? Will they be able to return home on their own? Will they be able to engage in the activities that they've engaged in pretty much their entire adult life? So it is very, very important, and Katie will talk about that even more.
Yeah, so to expand upon a little bit of what we've already spoken about, again, the role is really to make those medical decisions for you when you cannot make them due to permanent or maybe temporary incapacity. That person could be called to speak on your behalf after an accident, after a complication, and they might not necessarily be making decisions for you permanently, but they might need to help dictate your care until you are able to be weaned off of a machine or taken off medications that might prevent you from being able to speak for yourself. So them having a good understanding of what your goals of care and what your quality of life is are so important. A healthcare agent should really also be someone who's going to request consultations, ask the right questions. That goes back a little bit to having that comfort level in medical settings. No healthcare agent has to be a medical professional. They don't have to have an MD behind their name or be fully aware of all the medical interventions available, but be able to speak up, be able to ask questions, be able to make sure that just because the care is being provided, is this the right care that's being provided? And are there certain avenues or alternative measures that could be taken? They might not necessarily move forward with those paths, but just having that knowledge usually will help someone feel more comfortable in their decision making. Being a healthcare proxy, you're going to be consenting or refusing medical care, which can sometimes be pretty overwhelming to disagree with the physician or request a second opinion. Usually in these type of scenarios, it's a very heavy emotional type situation. So that healthcare agent really is going to need to, again, put their emotions aside and be able to really follow through with what your wishes are. Again, being informed of your medical conditions and your current health status is also so important. A healthcare agent is usually overseeing your care after that sudden medical event or emergency too. They may not be the person who is stepping in and able to set up things or handle any of the financial aspect. But when it comes to your care, they're the person that's usually going to be contacted by the physicians. They're the person, if there's caregivers involved, if there's an assisted living or any other healthcare professionals, they're going to become that mouthpiece. So they really need to understand the different levels of support and the different prognosis and circumstances that someone's going through. So really, I think the role of the healthcare agent is someone who's also very good at building a team and understanding who each point person is, not being the person to make every single decision for you, but a lot of the times a health crisis what kind of sounds the alarm. So now we're contacting this person, we're getting the person who can handle the finances involved. You know, they're kind of the person who's going to be dictating what's going to happen and making sure that the right people are in place. And that again ties into them being your biggest advocate. Being a healthcare agent is not something that is easily done. It is not anything we can prepare for either. I think that is what is the biggest surprise to a lot of people. When you are selecting someone to manage your finances or manage your estate, you can really kind of spell out, dependent on what your means are, what you want for each person, what you want for the status of your home, you know, all of your personal belongings. But with your health, it's so unpredictable. So that person really needs to be able to respond in whatever circumstances happen. Oh, I think Ken, you're on mute.
Thank you. And one of the things I want to emphasize is if somebody is not terminal and dies after the healthcare agent makes decisions, there's lots of people who, you know, will say, okay, I'm okay now. I'll go to my doctor's appointment. And then your agent will say to you, so what did your doctor tell you? And there's a reasonably good chance that they didn't hear, they didn't understand, they were too nervous, they just went through a traumatic event. And to me, the benefit of having your agent or somebody capable with you who is at your doctor's appointment is huge. I mean, I started taking notes, you know, back on index cards when I was in my 30s, just as to what my doctor was saying, so I didn't get the wording wrong, in part because my sister's a doctor across the country. I could call her up and tell her about it. But there's a lot better reasons than that as we age, as we suffer from medical conditions and treatments. And having a third person there who is going to listen, going to understand, going to question the physician, you know, in just a regular follow-up doctor's appointment in a medical office is frankly essential, at least in my experience, from the clients I've had, from the relatives I've dealt with, and from what I've seen when you have people like Katie, it's a care manager going with people to doctor's appointments. So that's something to consider doing sooner rather than later. And if it's not your agent under the healthcare directive, it could be somebody else who might be able to do that and write notes and send them to your healthcare directive. So, one of the issues is what happens if my agent is making a decision that I don't like? And as long as the doctor thinks you've got capacity, or frankly, if the doctor's not entirely certain you have capacity, if you are expressing objections to your agent's decision, I suspect that the doctor is not going to follow it. That's a risk management issue. It's not just complying with the desires of their patient, because the patient is the patient, the agent is not the patient. But I think you could pretty much expect that the doctors will listen to you if you cannot, if you express a view contrary to what your agent is telling the doctor. Now, a couple things, and that issue actually arose one time in a story I heard a judge tell. I won't get into any details, but where somebody had gone into a hospital for a relatively routine surgery. Something happened before the surgery happened. They hadn't signed the consent. The physicians called the agent. The agent said, I will not sign the consent. The physician said, wait 1 second, the patient was going to sign the consent. He'll be fine. We just need to do this. It's not that big a deal. The guy said no. So they went to court. And one of the things that judge who decided that case told the Bar Association meeting was, don't bring these things to court. I'm not in a position, this is not my area of comfort in making decisions. And the legislature has actually expressly said that, keep it out of court. Courts are not the appropriate place to resolve these issues. So hopefully by communicating, because communication or lack of communication is the cause of many disputes, not just in the estate planning field, but in other fields, communication is essential. So, the legislature, again, just underlying the healthcare directive and why do we have this law, expressly recognizes that every adult has a fundamental right to control the decisions relating to his or her own healthcare, including the decision to withdraw life-sustaining treatment, or to withhold life-sustaining treatment. A doctor doesn't necessarily have to agree with you. Family members don't necessarily have to agree with you, because every person has that right. And the legislature also recognizes, as I think we discussed earlier, that the prolongation of dying for a person for whom healthcare does not noticeably improve their condition or recovery could violate the patient's dignity and cause unnecessary pain and suffering, while providing nothing medically necessary or beneficial to the person. I mean, what does the patient get if they live for another 5 weeks or 5 months? Is there any benefit to them? Often the cases that there is, and often the cases that there's not. So it's just a matter of the agent figuring out what is beneficial and what is not. One of the things that some people worry about is, I'm not appointing a family member for my healthcare decision maker because I don't trust them, I don't want them, or they have some beliefs that I don't share with them, and they're going to try and impose them on my healthcare, and I don't want that. So I'm appointing somebody else. Is there anything I could do to prevent them from interfering? And the answer is yes. California does allow, and this is one of the areas where if you want to prevent a person or a public agency of one of the forms described from interfering with the decisions of your healthcare agent, it essentially deprives them of standing in probate court. So as long as they have $465 or whatever the filing fee is at the time, they could file something in probate court. But if you've gone to an attorney to complete your healthcare directive, and the attorney has complied and ensured you've complied with this provision of law, which also includes the lawyer signing a certification, then you can prevent people from interfering, specified people from interfering with your healthcare decision making. So that is something that is a real tool that people have who have concerns about interference, and provides a bit of protection to the healthcare agent as well, because having to deal with this in court when you're an agent making a terribly difficult decision, hopefully not too difficult, because hopefully you know exactly what the principal wanted, to then have it challenged in court is going to increase an already stressful situation. So it is a good tool to use. And so if you're in that situation, you should talk to your estate planning attorney about doing what he or she can to ensure that people are prevented from interfering. Somebody can revoke a healthcare directive, pretty much portions of it you could revoke orally, but the designation of an agent, the written designation of an agent, is not something that you could revoke orally. You need to revoke that in writing. One of the other things that happens sometimes, if people will designate their spouse as their healthcare decision maker and then they get divorced, the designation of the former spouse is automatically revoked by operation of law. Now, there are some people who get divorced and who still want to rely on their former spouse to make their healthcare decisions. So, I would say execute a healthcare directive after the divorce and expressly explain that in spite of the fact that this person is your former spouse, you want them to make healthcare decisions for you, and I think it will be enforceable. Now, there's a provision for the appointment of what are known as healthcare surrogates. You'll see the term surrogate used in different contexts in different states, in California for a number of years, because there's an old part of this law and a new part of this law. The old part I have some issues with. The new part I think is excellent. A person can orally designate an adult to act as a surrogate by personally informing verbally the healthcare provider or the designee of the healthcare facility that they want a particular person to act as their surrogate. And the healthcare provider has obligations to note that in the patient's record. And once that happens, the surrogate has priority over the appointment of an agent under a healthcare directive. And that is what I consider to be problematic, because I understand why that might have been the law at some point, but we sometimes don't appoint logical people as healthcare agents. We also don't know if our neighbor is going to come in and say, I'm here to make decisions for my brother. And, depending on what situation you're in mentally or when you're in, or physically when you're in the hospital, and most importantly, there's some children who won't designate, and they'll designate other children. Sometimes as you've weakened, if a doctor, if somebody is there who says, I'm ready to make decisions, and the doctor wants an immediate decision maker, the doctor may say to the patient, if you say orally that you want this person as your healthcare surrogate, I'll note it in the records and I'll start listening to them and following their directions. So I think it has a measure of danger, but that's just my personal view. A surrogate designation is effective for the shorter of either 60 days from when it's made in the particular facility, or during the course of the treatment of that illness or stay in the institution when it's made. So there's a lot of people who don't last 60 days in a hospital, but if you do, and you've made an oral designation of a surrogate, it would have to be renewed if you're going to be staying in the hospital. If you're sent from the hospital to rehab, then you may have to make another oral designation, or they will start paying attention to your healthcare directive, to your written designation. So, just in terms of the priority of healthcare decision makers under California law, again, number one is the surrogate who's been orally appointed once you're in the facility. Number two is the agent under the written directive. And number three, if a court appoints a conservator of the patient and gives them authority to make healthcare decisions for the patient, then that, and sometimes in conservatorships in California, the courts will, as a matter of course, revoke the healthcare directive, which I think is not a good thing, but unless the conservator or somebody involved has shown that it was obtained, the designation was obtained by undue influence or something like that. But that's the priority, and the healthcare directive is number two to surrogates. But you still should have one. You shouldn't bank on being able to orally designate a surrogate. Now, I said there was a good portion of the law that I really liked, and this is it. This was effective on January 1 of last year, I believe. This follows what a lot of states have had in place for a long time. If there is no written directive or ability to appoint a surrogate, then healthcare providers have a ability to make a decision as to who will make healthcare decisions on the patient's behalf, as appropriate in the particular situation. And the law says it needs to be an adult who has demonstrated special care and concern for the patient, is familiar with the patient's values and beliefs to the extent known, and reasonably able and willing to serve. But then it gives a list of people with priority, which is the list that I think most people would want. And it is what happened to the slide? It is going to be the spouse. It is going to be a child. It is going to be along those lines that the doctors can designate and decide who they're going to be listening to, what you would expect from on a statutory basis. Now, there are some obligations of healthcare providers in terms of if a decision is made, they're supposed to designate the or talk to the agent and tell the agent that the principal, and talk to the principal as to what was made, the decision that was made. A lot of times the principal doesn't have capacity, so that's just a formality in part to protect principals, in part to for the benefit of the healthcare provider. Let me just say, back to the list, it's not in one of the slides, but it's in my outline which is in front of me. In terms of the priorities, it's a spouse or domestic partner, an adult child, a parent of making a life and death decision on behalf of a child is a very difficult position to be in. An adult sibling of the patient, an adult grandchild of the patient, or an adult relative or close personal friend. So that gives the benefit to the healthcare providers. They get a designated person, and it gives a benefit to the patient because even though they haven't designated anybody in writing, or the writing has not been found, which happens with, I think, some regularity, it at least is going to find somebody to make decisions on the principal's behalf, on the patient's behalf. So there are situations where agents and principals may want to make some decisions that are contrary to the policy of a particular hospital or hospital systems, usually one that's run by a particular religious order, and California does not force the hospital to comply with directions that are against their policies. But they do have to make every effort to advise the patient that they're not going to be complying, to advise the principal that they're not going to be complying, and to offer to assist them in transferring to a hospital that is not governed by the same policies of that particular healthcare facilities. So, that will enable people, because again, we don't often control what emergency room we're being taken to. It's generally the closest one that's an appropriate one. That helps make sure that the patient's wishes will be honored, even if they're not honored in the particular facility that they're originally taken to. And this last slide is really just saying, don't forge a healthcare directive. It is considered homicide potentially. So I'm not a criminal lawyer, but I think that's a serious charge. So you don't want to mess with that. And if somebody has one, that's great. If somebody doesn't have one, don't forge it. And the question is, who would forge it? Well, there's some people who try and manipulate people once they are older or once they lose capacity. And so this is appropriate to be able to charge somebody if they actually forge a healthcare directive, and it has negative implications for the patient principal. So we also have at the end of the slides resources on healthcare directives. So take a look at those. The Conversation Project has a lot of issues that people like to discuss or are appropriate to discuss in this context. The Ventura County Coalition for Compassionate Care has additional advanced planning resources and are linked to the state side of the same organization. So we certainly suggest you take a look at the resources that are available. Guess we could pull up the questions and answers and see if,
Yeah, thank you so much. We do have just a couple questions. This is probably a good screen to leave up though, so people can write things down. But just to let everybody know that a copy of the slides will be emailed to you all along with the link to the recording, so that you'll have all of this wonderful information available to you. So thank you. We just have two questions, and so in this last couple of minutes, I think we can answer them. What the first question is, if a healthcare directive has been done 15 years and needs to be updated based on changes in agents due to death and other reasons, is there a way to change it without selecting an attorney?
again, a number of these forms are able to be completed without an attorney. The California Medical Association, just the forms we discussed. Make sure they're completed properly. I would not suggest just crossing out what's in the document that may have been notarized 15 years ago and putting something different and initialing the change, because that wasn't the document that was notarized 15 years ago, and it may end up creating some significant problems and invalidating the document. So you don't always have to see an attorney, but you should get to somebody who has experience. And I think Senior Concerns sometimes has people available who could help. And just don't cross out. I think the next one, the list of some of the scenarios. Katie, do you want to discuss that one?
Oh, I can't see the
Oh,
question.
okay. It says, can you make available a list of some of the scenarios and questions that would help elicit the information for treatment?
Oh, sure. I can definitely pass those along. And also the conversation project and prepare for your care, those forms help talk about certain scenarios and kind of go past just selecting the healthcare proxy. So those are also some good tools to use.
Definitely, thank you.
Do I know why the Public Guardian's Office does not sign a pulse for the people they're in charge of? The answer is no, I don't. I could speculate, but I'm not going to do that. They do what they want. Can we get my information as well? If you Google my name, you'll find me. If you go to the Solo Aging Solutions website, you'll find me. Okay.
Those are all of our questions.
Good.
You did it.
Okay.
Oh my goodness, thank you so much. That was full of such important information, and hopefully everybody will re-look over these slides and really use this to think through carefully what they want their wishes to be and start having some conversations with their loved ones. One more just popped in. Oh, just a thank you. Thank you so much to our speakers. Thank you to all of you for joining us today, and I hope everybody has a wonderful evening.
Bye-bye.
Thank you, Martha.
Thank you.